Hello, thank you for joining us for this presentation in the Oklahoma State Historic Preservation Office's Section 106 Winter Workshop Series. I'm Christina Wyckoff. I'm the Section 106 Coordinator and Historical Archaeologist at the Oklahoma State Historic Preservation Office. And I am joined today by Jamie Lee Marks, Senior Program Analyst in the Office of Native American Affairs in the Advisory Council on Historic Preservation. And she'll be presenting on tribal consultation in the Section 106 process. Thank you so much for joining us, Jamie, and I'm going to hand it over to you.
All right. Good morning, everyone. I'm so excited to be here. Thank you so much, Oklahoma State Historic Preservation Office Superstars, for having me as a part of this series. Here to share just a little bit about my and ACHP perspective on tribal consultation and Section 106. I'm going to leave my camera on for a little bit, but there's kind of you might notice a lag between the sound and my video. So in a little bit, I'll turn my camera off so it's not distracting. First, I just want to go over my objectives for our time together today. As you know, tribal consultation could be a multi-day class. I certainly can't do it all today, but I'm hopeful to give a general overview of the bigger context for tribal consultation and the government-to-government relationships between tribes and U.S. and federal agencies. From there, in the second part, really want to focus and kind of zoom in on the Section 106 context, as well as key opportunities and challenges that present themselves in that context. From there, I'm hoping, since we have a bunch of you here with experience, that we can have a discussion and some question answer time just to discuss key challenges and promising practices for effective consultation. To that end, here's what I'm planning to discuss, so that along the way, if you're wondering, well, she's talking about this, why isn't she talking about that, you kind of have a map for where I'm planning to go. I first am going to start talking about the big picture, 30,000 feet level tribal to federal relationship, excuse me. From there, the what and the why, the general federal tribal consultation, frequently asked questions and hot topics. We'll talk about some key laws, executive orders, and then drill down into the specifics of the NHPA. From there, some key concepts that we see come up in our work to assist the ACHP and also our federal agency partners are ones that I want to single out: removal and ancestral land, sacred sites, and the importance of Indigenous knowledge throughout the process. From there, what some people call best practices, but as someone I really respect and get to work with often says, I don't know if we've hit best yet, right? So some good or promising practices. And from there, kind of a tour of the resources we have in case you want to take a deeper dive into any of the topics that I bring up. Okay, first, I do have, well, I should not say me, because Christina was so helpful and helped me load these. I have some questions in the polls section. And I think, actually, Christina, this is going to be me trying to explain how to get to polls and maybe not knowing. But if you can see across the top, it says chat, question and answer, polls and handouts. If you could take a second to click the polls and respond to some questions. The first is about your experience with tribal consultation, and the second is about the type of entity that you work for or represent. Some great answers. I'll give it another minute. Awesome. So far, what I'm seeing is that we've got a bunch of folks on here that are familiar with tribal consultation, or that do it as an everyday part of their job, or that feel extremely confident in this area, which is great. That means that when we're kind of discussing maybe some of the grayer areas or more difficult parts of this conversation, we can draw on each other's expertise, and that's great. I see that we have a Fed who snuck in here, a federal agency or program representative. Just kidding. I love y'all. Not sneaky at all. Glad you're here. Folks that work with state agencies or offices, or the majorly represented demographic here, and then folks that work for tribal government or tribal department, which is absolutely great. I'm surprised to not see anyone from an academic institution sneak in here. Usually not that it's sneaky, but usually that's something that I see. That's great. Thank you so much for taking the time to do that. It'll help me kind of tailor the discussion a little bit to the specific audience. In terms of me, so my name is Jamie Lee. I work, as Christina said, for the Office of Native American Affairs at the Advisory Council on Historic Preservation. Some of you might know me from a different job. I certainly have gotten to work in the past with the Oklahoma State Historic Preservation Office I used to be the Tribal Historic Preservation Program Manager at the National Park Service. So I've been with the Advisory Council now just since March. And so a lot of kind of the angle of vision and perspective that I bring on things that I say here has to do with some of the guidance from the Park Service Tribal Historic Preservation Program. And so if you're like, I think I know this lady, her voice sounds familiar, her name, you probably do. I have seen some friendly faces pop up in the chat, so that's great. A little bit about the ACHP. So we are an independent federal agency, which means we don't exist inside of any other federal agency. We are a standalone, small but mighty team. Our mission is to promote the preservation, enhancement, and sustainable use of our nation's diverse historic resources and advise the President and Congress on national historic preservation policy. We do, as y'all know, I'm sure, participate in... Oh, great. Sorry, I'm seeing more titles in the chat now. I just realized that was there. Oh, great. You guys are awesome. We do participate in some Section 106 cases, right? There are instances where the ACHP participates. It's my understanding that y'all have been covering topics like that all this week, and I'm excited to hear it. So in terms of the agencies whose projects you might see my name floating around, Bureau of Ocean Energy Management, Bureau of Indian Affairs, National Park Service, and Bureau of Land Management are the ones that I work with the Office of Federal Agency Program case managers on, should any questions or need for discussion arise there. So Office of Native American Affairs, we are, again, a small but mighty team. What we do specifically is advise the Advisory Council chairman, members, director, etc., on policy matters and historic preservation issues affecting tribes and Native Hawaiians. What that means is in order to advise on issues that are important to y'all or to folks in that arena, we need to hear about them, right? So we do spend a lot of time with listening sessions, having meetings, building relationships, and hopefully we can be that kind of long-term office there that can be that voice in the places that is appropriate for us. We work to ensure the ACHP itself as a federal agency meets our government to government consultation and trust responsibilities. More on that to come in the presentation. And we do all sorts of, I actually casually like to refer to our office as getting in ACHP's business and getting in everybody else's business. We provide technical assistance, training, outreach throughout federal government within our own agency. And part of my job that I think is really exciting is we get to participate in these bigger interagency initiatives related to tribes and Native Hawaiians. So, right now, our office has been a big help in supporting the ACHP's participation in the White House Council on Native American Affairs. You might have seen that there was a White House Tribal Nations Summit last week, and we'll be talking a little bit about some of the news that came out of that. But we have been able to work through that interagency group to advance some guidance around Indigenous knowledge, some new uniform standards for tribal consultation for federal agencies. Climate change is another big initiative that we look at through our participation there. So it's just a really exciting part of our work. We also recently have signed on to a Native Languages MOU. So we're looking at ways that we can, within the historic preservation world, work to advance the preservation of Native languages. I'm sure in the future, we're going to be asking folks to help advise us on that or to hear your thoughts on what that might look like. But a key part of that for us is our Native Youth Internship. We have a partnership with Salish Kootenai College where we work with their tribal historic preservation students. It's the only tribal historic preservation specific degree program in the country, as far as I know. And we work with them and host them as interns at the ACHP and integrate them fully into our everyday work at the office. So it's pretty exciting. And thanks for indulging me in here's a little bit about our office. We are, like I said, a mighty, small but mighty team of three. Ira Matt is our director and sends his regards. He could not be here today because he has a travel obligation. So I'm here. I'm the senior program analyst. And then I know many of you have worked over the years with Bill Dancingfeather, who is a program analyst in our office. And man, Bill's busy. He handles our training and he works with all of the other agency cases that I didn't mention. So I'm sure you can imagine what that looks like. All right, I'm going to mute the video now because I think the lag is distracting me. And I don't know if y'all feel the same way, but it might be helpful. All right, so to kick it off, just a tiny topic. Just kidding. A big and important topic is the U.S. legal relationships with tribes. So, as many of you know, the United States has a unique, legally affirmed nation-to-nation relationship with American Indian and Alaska Native tribal nations. That has been recognized under the Constitution, treaties, statutes, executive orders, and court decisions. The relationship has been defined and clarified over time in legislation, executive orders, presidential directives, and by the Supreme Court, and is just a really important part of the context that tribal nations have when they're interfacing with the federal government in terms of federal decisions, including those pursuant to 106. So, of course, the Constitution lodged broad power in Congress under the Indian Commerce Clause article that states Congress shall have power to regulate commerce with foreign nations and among several states and with the Indian tribes, which is the quote there, as subordinated to federal power. The Supreme Court over time has described the Indian Commerce Clause as the primary constitutional basis for federal exclusive and plenary power over Indian affairs. So how does that show up in the federal agency context? The U.S. trust responsibility is a well-established legal obligation that originates from the unique historical relationship between the U.S. and Indian tribes. The trust responsibility is a legal obligation under which, and this is a quote from Seminole Nation versus United States 1942 decision, has charged itself with moral obligations of the highest responsibility and trust. And this includes the protection of tribal and individual Indian lands, assets, resources, and treaty and similarly recognized and reserved rights. Each agency defines the scope of its trust responsibility to tribes. So the ACHP has our own policy on our understanding of our trust responsibility that I've added to the handouts that you have access to. And it states that the ACHP's trust responsibility is to ensure that its regulations implement the requirements of 106 and that such regulations incorporate the procedural requirement that federal agencies consult with tribes that attach religious and cultural significance to historic properties. Questions regarding any federal agency's trust responsibility to tribes should be directed to their tribal liaisons or coordinator or Office of General Counsel. The ACHP can't define such a scope for others nor advises other agencies on this issue, but it is really important for you to keep in mind that rightfully, any tribes that you're working with have this relationship with the U.S. government. So just a little bit more about this. It's a responsibility held by all federal agencies. It does require a respect for tribal sovereignty and self-determination, which includes the right of tribes to make important decisions about their best interest. Upholding this responsibility in places that I've worked in policies, especially at Interior, one of their policies is upholding it means being responsive and informative in all communications and interactions with tribes and individual tribal members. The ACHP, again, in our view of our trust responsibility, views that responsibility as encompassing all aspects of historic resources, including intangible values. So for us, recognizing the importance of places, sites, landscapes, to the perpetuation of heritage of tribes and their historic resources is really important to us in terms of meeting our mission. So it is an exciting time to talk about tribal consultation. It's very timely. It's almost like this presentation couldn't have been timed at a more exciting time. We recently, the ACHP and a bunch of federal agencies, as well as the White House, participated in the Tribal Nation Summit. And one of the major announcements coming out of that summit was the development of a memorandum on uniform standards for tribal consultation. So for those of you here, especially those of you that ranked yourself as I have experience, I do this every day. As you know, one of the main challenges in terms of tribal consultation with U.S. agencies is that they all tend to approach certain parts of it differently. That, in theory, is meant to provide flexibility because, of course, 574 federally recognized tribes are different governments, and there need to be individual relationships and approaches there. But the lack of uniformity in how federal agencies approach it sometimes can be a little bit frustrating. So the presidential memorandum established uniform standards to be implemented across federal agencies that respond to input received from tribal nations over the past year and a half. There have been several consultations around this. The memo will include a requirement for federal employees to engage in regular annual training about tribal consultation. So that's exciting. And we're going to look at some of the language in this memorandum in a minute. It's also another thing kind of uploaded to the handouts for further reading if you're interested. The White House also announced that several agencies will be updating their consultation policies as a result of, aligning to this new memorandum. That includes Interior, Department of Justice, DOT, NOAA, Department of Homeland Security, Health and Human Services, Treasury, Army Corps, and the Advisory Council on Historic Preservation. So we're going to be busy working on that in the upcoming year. Okay, so that said, so we're going to go with the what is tribal consultation? So as discussed in this memo and in Executive Order 13175, tribal consultation in general is a two-way nation-to-nation exchange of information and a dialogue between official representatives of the United States and of tribal nations regarding federal policies, programs, and initiatives that have tribal implications. Right. So one of the most important parts of this new language is the emphasis on two-way. Right. I think we've all been a part of meetings where it's positioned as a dialogue, but is just someone presenting information. This really clarifies that no, this is not just one side presenting information. This is a dialogue between two sovereigns. The broader picture also is that consultation recognizes tribal sovereignty and that nation-to-nation relationship that we've been talking about, and recognizes certain treaty and trust responsibilities. Again, very important context for all of you going into the environment of thinking through tribal consultation, even within a 106 context. Consultation requires that information obtained from tribes be given meaningful consideration and that agencies should strive for consensus or a mutually desired outcome. That is new language in this presidential memo. Consensus is a major emphasis of this new work. So, in terms of talking about this bigger picture, those of you especially working in implementing programs in a designated capacity, it's important to note that a federal agency might be consulting on a broader level pursuant to Executive Order 13175 alongside or in addition to 106 consultation, and that these are the sorts of concerns that in your consultation planning you might want to think through. So what does that exactly entail? I say think through. That's not really that helpful of guidance, is it? You want to include federal and tribal officials with decision-making authority regarding the proposed policy, project, or initiative that may have tribal implications. This may have tribal implications part to me is really important because, over the years, I've seen in my career a great many of conversations start with, well, I don't think tribes will be interested in X, Y, or Z. Well, you wouldn't really know, right? Unless you have that relationship or you have an ongoing conversation about priorities and interests, which is why relationship building is such an important part of this entire picture and this entire universe, right? Sometimes it's hard for outsiders to understand what things could have implications. So knowing that this is the responsibility of federal agency, it is important to communicate, right, when you think something could have tribal implications. It should be considered consultation by both parties. I don't know, if y'all have had this experience, but a federal entity saying we had official consultation with XYZ and tribal leadership saying that was not consultation. That was a phone call. That was pre-consultation. That was coordination. It should be very clear and formalized when something is tribal consultation. It is information sharing and the consideration of input. So it's not just, again, sharing information. It's sharing it so that it might actually influence the outcome. And engaging early enough in pre-decisional planning that tribal consultation can actually impact an outcome. I mean, we know that the way that this is implemented, that hasn't always been possible, but this is what it is supposed to be, right? So that is the thought. Ongoing commitment to relationship building, between governments essential to this, and of course, sensitivity to concerns about confidentiality. So that has been front and center in the new guidance, being very clear about, what things you can and can't protect in terms of information that's shared with you, and being creative with your partners about how to share information in a way that, maybe only what is the bare minimum that is necessary could show up in the administrative record to justify a decision, et cetera. Very important part of this picture. Why I feel like it's fun talking about this in this presentation. I probably don't need to. It sounds like y'all are very much already on the why train here, but moral and ethical reasons, right? We live in a settler colonialist state. Every single acre of what is now called the United States is tribal land and has been occupied people stewarded since time immemorial. And it is the moral and ethical thing to do to consult with tribes about managing these resources, right? And otherwise shepherding us all into the future. Of course, we have federal agencies who are, legally mandated with the stewardship of land and resources directive or mission. And that's tribal consultation is an important part of that. I mean, I think even understanding land and the resources requires a substantive engagement, of course, with the people who know the most about it, right? Treaty obligations. Many tribes have entered into treaty agreements with the United States, and when projects are going to impact anything related to those treaty resources or reserved rights, of course, there's an obligation to consult, to understand. And that's a kind of an entirely different, consideration that we could spend 2 hours alone just talking about, but I'll leave it at that for now. And then some specific legal mandates, context in which tribal consultation is required. All right, so federal agencies, they work to uphold the unique legal relationship, right, through a number of varied statutes, executive orders, regulations, policies, missions, etc. What does that exactly look like? So here is just a sample of some that I'm sure you have some experience working with. We've got NEPA, right? In fact, I actually think that should say 1969, so that's on me. And the implementing regulations requires the preparation of an EIS for any proposed major federal action that may significantly affect the quality of the human environment. Tribal consultation under NEPA can include effects to treaty, trust, and other natural resource issues, as well as cultural resources in general. And I know that in your discussion of Section 106, you guys have talked about, I think, that you can coordinate NEPA with NHPA. But that's an important part of the broader government-to-government tribal consultation on federal decisions picture. Of course, the American Indian Religious Freedom Act establishes the policy of the federal government to protect and preserve for American Indians their inherent right of freedom to believe, express, and exercise traditional religions, including but not limited to access to sites, use and possession of sacred objects, and the freedom to worship through ceremonial and traditional rites. So, many practices have to happen in a place, and place is inherently linked to practices that are essential to the preservation of religious freedom. So this does become something that, like a Venn diagram, can touch on NHPA responsibilities, and it's really important to be aware of that. From there, of course, we have our superstar regulation of the week for this training, the National Historic Preservation Act, and implementing regulations, which requires federal agencies to consider the impact of their undertakings on properties of religious and cultural significance to tribes and Native Hawaiians, among other things, right? And more broadly, historic properties. We'll dive into that one, with the most detail. NAGPRA and implementing regulations, of course, has a federal tribal consultation component. On tribal lands, planned excavation requires the consent of an appropriate tribe. And in instances where a proposed project is funded or licensed by a federal agency that might cross federal or tribal lands, it is the federal land managing agency that is responsible for compliance with NAGPRA. And of course, detailed information about consultation in the NAGPRA context is available through their program. And, I know that right now they are engaging in consultation about some updated NAGPRA regulations right now. So if that's your area of interest, this is me flagging that those consultation sessions are coming up, and you should check them out on the NPS website and participate. All right, so now to the executive orders. We've got 13007, which is an order titled Indian Sacred Sites from 1996. It applies to all federally owned lands except, quote, Indian trust lands, and encourages land managing agencies to accommodate access to and ceremonial use of Indian sacred sites by Indian religious practitioners and, quote, avoid adversely affecting the physical integrity of such sites. So I'm sure if your alarm bells in your head are ringing off, wow, that really does Venn diagram quite neatly with a lot of our concerns under the NHPA. That makes a lot of sense, right? And it does make sense in the course of consulting pursuant to a 106 undertaking that could impact a sacred site to consider an agency's obligations under this executive order. Six, the one that I think I hear the most in my day-to-day job, Executive Order 13175, is that broader responsibility for federal agencies to consult with tribes. It applies to all agencies other than those considered independent federal agencies, encouraging meaningful and timely consultation with tribes and consideration of compliance costs imposed on tribal governments when developing policies that may affect tribes. And again, highlighting that may affect tribes, because for me, in practice, that's one of the biggest difficulties of this terrain is how do you anticipate what may affect tribes or a specific tribal nation without having that relationship and that ongoing trust and communication. And then we come to now, right? So we see under the Biden-Harris administration a memorandum, Tribal Consultation and Strengthening Nation-to-Nation Relationships, that required all federal agencies to submit a consultation plan of action. 50 agencies submitted a consultation plan of action for the very first time. So if you have worked with agencies for a long time and say, oh, they don't really have their own consultation plan of action, you might want to take a peek and see if as a part of the deliverables for this year, they did update that. Very important. The presidential memorandum, Uniform Standards for Tribal Consultation, that we just went over. And then something that I'm very excited about and excited to talk about is guidance for federal departments and agencies on Indigenous knowledge. So during the summit, a first of its kind guidance document was released regarding Indigenous knowledge. It includes promising practices and asks agencies to consider Indigenous knowledge during research, policy development, planning, and implementation, ensuring that it is recognized, valued, and included and protected, and considers Indigenous knowledge a valid form of evidence in policy and scientific contexts. The ACHP actively participated in the development of this guidance and looks forward to continuing our roles supporting it, and we're hoping to, incorporate it into everything that we do here over the next few years to update our policies and guidance. And then, of course, all of this big picture tends to filter down into agency-specific consultation policies pursuant to 13175 and the implementation of these presidential memoranda, right? So when the government says, hey, you need to have a plan for incorporating Indigenous knowledge, agencies are like, okay, here's our plan. So it's another very important part of the puzzle in terms of thinking through what have federal agencies said that they were going to do. I'm going to jump into the NHPA next, but I just want to make sure there's no major questions about the broader context that I might have missed in the chat or anything like that.
We don't have any questions in the chat just now, but please do feel free to enter your questions there and into the Q&A. And I am monitoring both of those. So we don't have anything at this time, but I can let you know if we do.
Thank you. That's so nice. I very rarely in my career have gotten to present with somebody so kind and helpful. Usually it's sink or swim, right? Manage it all, figure it out. But that's super, super nice. Thank you. Okay. So National Historic Preservation Act. I assume that this is, that I don't need to spend a lot of time here. Y'all know about this law. You've been talking about it all week with your lovely stewards at Oklahoma. Of course, established the National Register of Historic Places, created State Historic Preservation Officer Program, and Section 106 instructs federal agencies to take into account the effects of its actions on historic properties. It also affords the Advisory Council on Historic Preservation a reasonable opportunity to participate and comment in those circumstances. So what does this mean, in practice? So again, requires federal agencies to consider the impacts of an undertakings. And this is where things tend to get a little grayer, right? Fund, carry out, or assist. What does assist mean, right? Funding, how does that look? Permit, license, or approve. So this is a bigger obligation than I think sometimes it seems at first glance. And then, of course, its impacts on undertakings on properties that are eligible for the National Register, not listed, right? So this is a much broader picture than, again, I think it seems at first glance for many people. And those include sites with religious and cultural significance to tribes, Native Hawaiian organizations. So a big responsibility, and one that cannot be carried out without tribal consultation, right? In 1992, the NHPA clarified that those properties of religious and cultural significance may be eligible for the National Register, and requires agencies to consult with tribes when historic properties of religious and cultural significance to them may be affected, right? The 1992 updates also created one of my favorites, obviously, the TIPO program. Through the years, of course, the number of tribes that have entered into a formal agreement with the National Park Service, taking on historic preservation officer duties, lead historic preservation officer duties on tribal lands, has increased from 12 to, gosh, I think they're at 213 now, which is great. So, of course, current challenges there continue to include consultation coordination, various what's the word I want to use? Challenges about jurisdiction, right? Like, who is the lead HPO tends to be still a complicated question for folks, even though the regs are quite clear about instances like that. Although I know that it's not always the regs that are the least clear part of that terrain. And of course, in our work over here at the Advisory Council, we have guidance about the role of the Tribal Historic Preservation Officer on and off tribal lands, that if you're ever into a circumstance that you want some clarification or some backup about a claim you're making about them, can be wildly helpful. All right, so the Section 1 review process. So here's the part where I say out loud again that I know you've been talking about this all week and that you're likely experts in it by now, but some of the things that I want to point out about it is that the Section 106 review process is 4 steps and includes consulting parties throughout. Tribes, or consultation specifically with tribes and TIPOs, is a crucial component of this process throughout. It is central to achieving every step of this, and it's not something that is just popping up in identification or just popping up in addressing adverse effects. It's not even just popping up in once the APE has been established. This is really something that should be going on throughout. It is you'll see it on the left here. It's kind of the backbone of the process, is consultation in general. It's not meant to stop projects, but provide federal agencies a pathway for decision-making that is informed by other important groups of people and by tribal nations and governments. We've already talked about kind of the definition of undertaking, but the language, I think, in 800.1 is really important to our discussion of tribal consultation, and that seeks to accommodate historic preservation concerns with the needs of federal undertakings through consultation among the agency official and other parties with an interest in the effects of the undertaking on historic properties. The goal of consultation is to identify historic properties potentially affected by the undertaking, assess its effects, and seek ways to avoid, minimize, or mitigate any adverse effects in that order, right? So tribes and tribal consultation really should be, and is supposed to be, in terms of the regs, is a part of this 4-step process. Gosh, we love the regs over here at the HCHP, don't we? So, just to dive back into the regs here, here's the language directly from the NHPA in carrying out its responsibilities under Section 306-108 of this title, which is just new citation for 106, even though none of us are saying it, right? A federal agency shall consult with an Indian tribe, any Indian tribe or Native Hawaiian organization that attaches religious and cultural significance to a property. So that attaches, the only way to know, the only person, the only group that can tell you if they attach significance to a site is a tribe, right? Or in this case, and I know that's outside of the scope of what we're talking about, a Native Hawaiian organization, right? So it's very clear in the regulations that this is something that is identified by the tribe. So, that can get sometimes complicated, right, for folks to understand for some reason, especially because tribes ascribe significance to properties located in ancestral territory areas far from where they currently reside, and the regs apply regardless. So this properties of religious and cultural significance for folks that are new to this space sometimes can get a little confusing. What does that mean? What can it look like? We like to use photographs that show that if you're an outsider to a community, or even if you're part of a community but not part of that community that has access to certain information, traditions, and practices, you cannot identify those as an outsider, right? So locations of religious, sacred, or ceremonial activities, locations that are essential to the perpetuation of culture, language, ceremony, health, medicine, and heritage, right? Possible burial areas or areas associated with ancestors and ancestral remains. And then, of course, buildings, former capitals, council houses, schools, homes of important historical figures. There's also features of the landscape or site that hold religious or cultural significance, especially in what people that are invested in the split between nature and culture tend to say are natural landscapes, right? Which we know that all landscapes are and have always been cultural landscapes also, but features of the landscape and site that hold special meaning that, again, might not be readily apparent to outsiders. Okay.
Jamie, we have a
Yes,
question that popped up in the Q&A. Adam
sure.
Russell writes, is there a reason Alaskan Native corporations aren't included in that wording?
Oh,
And it was 2 minutes ago, so I may have
oh my
missed
gosh, I'm so
exactly which
sorry.
wording he was referring to.
Is it this one?
We might be able to get a confirmation in the chat, Adam, if you're still
I'm sorry.
there. You you could clarify the wording here if that
Sure.
would work for you.
Yeah, I can 100% speak a little bit to this. The definition of tribes in the NHPA is interesting, right? And actually, I want to make sure to pull it up so that I can talk through some of the complexities there. It's all hinging on a comma. So Alaska Native corporations are included in the National Historic Preservation Act, right, in the definition of tribe, but it states that in this division, Indian tribe means a tribe, band, nation, or other organized group or community, including a native village, regional corporation, or village corporation that is recognized as eligible for the special programs and services provided by the United States to Indians because of their status as Indians. Now, many people have taken that to mean the list of federally recognized tribes, and in other agency consultation documents, their solicitors have decided that it very clearly does mean Alaska Native corporations. And so at the advisory council here in our section 106 handbook, I've seen lines in it that have maybe conflicting information about that, right? So I do think in many cases, yes, Alaska Native corporations are included in consultation for sure, but because they are not tribal governments, right, as defined here, that can be a little bit of a gray area. So those are, I know that I'm not directly, addressing your question because I am not in our Office of General Counsel, but I did want to just give you a picture of the terrain of the complexity there. But many agency consultation policies pursuant to 13175 do mention Alaska Native corporations, which is why it's so important to kind of arm yourself with the information from the agency. And please feel free to let me know. I'm very open to being told whether or not I've kind of given you enough information to be satisfying there. Oh, and thanks, Adam, for clarifying that slide. Yeah. So this is just the language directly from the statute. But I know that that's a topic, that's a hot topic, right? So I think following that thread and how it develops over time is going to be really interesting. And it's something that I'm excited to see how that goes too. Anytime. Yeah. So what is this? What is the actual, what are the statutes, the regulations? What do they say about federal requirements to consult, right? That means in the 106 context, providing tribes as defined in the NHPA, which again, all hinges on that comma and how people interpret what that means, the opportunity to identify concerns about historic properties, advise on identification and evaluation, articulate views on effects to historic properties, and participate in the resolution of adverse effects. So one of the challenges I have seen over my career is, of course, looping tribal nations in late when, there's already been a determination of eligibility, or the AP is already fixed, or the opposite, right? Including tribes and identification efforts, and then not necessarily talking through what could adverse effects look like, right? Because we as outsiders, and I say me, Jamie Lee as an outsider can't say, I fully understand all of the things that would have an adverse effect on this site's connection to culture, heritage, and history, right? So that's something that we can't say from the outside and is a really important part of the picture. We have a nice definition for consultation within the regs that helps us think this through further. Means seeking, discussing, and considering the views of other participants, and where feasible, seeking agreement with them. That's a pretty bi-directional description that I think is helpful in terms of, if y'all are working in this context and need something to kind of back up that consultation needs to be more bi-directional, there's some good, nice regulatory language for you. This also, in the background of these requirements, ensure consultation is initiated early enough to actually kind of have this ability to influence the outcome, right, and seek agreement. Oops, hold on. Back here. Other things that federal agencies must do according to our guidance: ensure consultation is initiated early, offer reasonable opportunity to consult, make a reasonable and good faith effort to carry out appropriate identification efforts, and acknowledge tribes have special expertise in assessing historic properties that may be of religious and cultural significance. So we do here at the Advisory Council have some guidance on what does it look like to make a reasonable and good faith effort to carry out appropriate identification efforts, as per 800.11, and that's gather information from any tribe or Native Hawaiian organization identified pursuant to 800.3. So any tribe identified as having any interest in the area of the undertaking, to assist in identifying which properties, including those located off tribal lands, may be of religious and cultural significance to them. Another part of our guidance on that states the agency officials shall make a reasonable and good faith effort to identify any tribe that might attach religious and cultural significance to historic property. So that means kind of the onus is on the federal agency to identify anyone that might be interested in an area that an undertaking may affect, and how the agency decides that it has undertaken that good faith effort. Really, that's really the agency's decision, but it's also something that the courts can weigh in on. So really important thing to think about. All right. So again, consultation more than just notification. We view it as the process of communication that may include handwritten correspondence, meetings, site visits, emails. And again, remembering that the point of consultation is not the administrative record, it's the exchanging of information, even though the administrative record can be really important. Tribal consultation should occur between tribal leadership and or their designated representatives and federal officials with decision-making authority. That is something that we see is really important to this context, or I should say I don't want to speak for we, but that is really has been important to positive outcomes here. Okay, folks that are new to the space, of which we didn't have many. So that's maybe this will be, again, some helpful review for all of us to think about. But who participates in the 106 process? On the federal side, federal agencies, managers, agency officials, folks with decision-making authority, often subject matter experts, can also be called to make sure that they're providing enough information such that informed discussions can happen, right? You don't want to have a consultation about an infrastructure project and not have the person there that can tell you, what certain data means about the impacts to water quality. That wouldn't be very helpful, would it? So sometimes helpful to have those folks in consultation meetings. Tribes, are their own governments, right? And they have, just like a U.S. government bureaucracy, they have different ways that they run their governments. Their tribal leaders, including chairs, presidents, chiefs, governors, council members, and then tribal staff, such as the Tribal Historic Preservation Officer, who for undertakings on tribal land is the lead historic preservation officer and might be the representative that is consulting on a project, or off tribal lands will likely still be there to comment on the impact of an undertaking on historic properties and resources. You might also have natural resources department lead, environmental protection, maybe tribal NAGPRA office, tribal cultural committee elders. These are some of the important, and it's certainly not the end of it, right? This is just a very short list of folks that could be important to a successful meeting. But of course, you're going to want to ask your tribal partners or tribal nations with whom you're consulting, to make sure that your protocols include all relevant participants on their end, and let them tell you that. So what's the deal with the lead federal agency? They have jurisdiction over the undertaking and approval authority. That's how that's one of the ways that lead federal agency is determined, because of course we do have projects where multiple federal agencies are involved. They can commit to appropriate actions as a part of 106 compliance. They take legal and financial responsibility for the compliance. So in terms of the delegation of 106 consultation initiation, there are limits on that with tribal consultation, and the federal agency remains responsible for that compliance. And we'll talk a little bit about that limit soon. There's something more to say about it, but there's a responsibility to make that reasonable and good faith effort to identify tribes and NHOs and ensure consultation is initiated early in the process. So cannot fully delegate Section 106 responsibility. The federal agency does have the ultimate responsibility. Typically, the things tribes consult the most on throughout the identification of the area of potential effects. Sometimes when federal agencies are trying to understand what is the full picture of what can be affected in terms of space by an undertaking, they don't always if that's, especially if that's not where those federal officials live, it can be hard to get that right? So consulting on the area of potential effects, the methodology used in identification. So one of the things that I have heard in multiple positions is that, sometimes there's an over-reliance, and no shade to archaeologists for sure. I'm sure you know where I'm going with this, but an over-reliance on material research, archaeological research, and maybe not as much of a reliance on oral history, ethnography. So really helping federal agencies figure out if they have the appropriate expertise to be engaging in identification research. And if not, kind of helping them, along the way, figuring that out. Determinations of eligibility. So, the NHPA is a very location-based law. And so, helping your federal agencies or state partners that are working to concur, not concur with the determination of eligibility, understand what are contributing parts of the landscape, taking into account not sharing anything that sharing might do harm to your community, but really having those conversations, how can we help you support a determination of eligibility, and what is the bare minimum of the information that we could give you, or just having those conversations in a really good natured way. Helping to affect on no effect, no adverse effect, or adverse effect findings, right? So federal agency is going to say, we don't believe this will have an adverse effect, or we do think this will have an adverse effect, and tribes consult on whether or not they concur with that. And then, of course, the resolution of adverse effects through avoiding, which comes first, minimizing, or mitigating the adverse effects. TIPO, I can't get away from talking about it. I think it's a really important program. Assume HPO duties on tribal land. It's really a 5-person job, often delegated to 1 or 2 people. So if, I see folks that work in TIPO offices here in the chat and in the presentation, and honestly, everyone in the historic preservation field, it's a very understaffed field with a huge responsibility and a huge weight on our shoulders, right? Preserving historic resources of our nations out there. So hats off to you. So appointed by tribal leadership, signatory to Section 106 agreements on or affecting tribal land. So that's important. And they are the lead historic preservation officer on tribal land. It's not a situation where, historic preservation officers approve or don't approve undertakings, but the process is meant to provide opportunities, significant opportunities for influence. That is the theory, right, of the whole thing, so to speak. So the reason I bring up the federal tribal relationship in this context is because it does influence every part of this relationship. Government to government relationship and protocols. It could be that your agency that you're working with, or that you're looking at an undertaking from an agency, has a consultation protocol with a federally recognized tribe, it'd be really important to know that and kind of consider what that looks like and what that means. It's important to take into account working through tribal government, right? Most of the undertakings that we're talking about, I'm sure in your training, are ones happening off of what is technically tribal land in the NHPA. And it's really important to remember that you need to send that kind of invitation to consultation directly to tribal leadership with a copy to the TIPO in those cases, right? Because that relationship is really important to this general picture. Throughout, recognizing sovereignty and treaty rights is an important part of this picture. The resolution of an undertaking's potential impacts to treaty rights is not a part of the Section 106 process per se, but actions associated with reserved and treaty rights may assist with the identification of historic properties. So locations where activities occur, especially like fishing, gathering, hunting, and resources associated with them, like earthen, botanical, non-human animal, as a statutory consideration, treaty rights must be accounted for separate from and prior to initiating Section 106. However, those locations or the actions taken at them may be a really important component of a contributing element to historic property. So again, it does fit into the general landscape. Ancestral Aboriginal and ceded lands, right? So we, those of us that work in history here, we know that the United States, what is now called the United States, is, it was entirely peopled, and there have been legacies and continue, to be harmful legacies of colonialism where folks have been removed from their lands, whether that's through treaty, whether lands have been unceded, but there was removal through other ways. Understanding that histories of removal impact and almost charge the responsibility of a federal agency to understand who is interested in the land where their project might occur. That's really important, right? So if you're somebody who, you are like, wow, I can't even tell you how many people I've heard at how many grades and how high at certain agencies being like, we don't have any tribes in X state. And I'm sitting here like, I can think of 13, right? So just do the deep dive, understand the history, speak to tribal liaisons at the agencies, try to understand the full picture. Possible consideration of other federal responsibilities, right? So say you're a land managing agency and you are engaging in something in an area that is a sacred site that is important to ceremony of a tribe, right? That site is eligible, has been determined eligible to be on the National Register, but is also a sacred site where 13007, which sounds to me like a spy every time I say it, but 13007 responsibilities might exist too. You can absolutely consider access to that site in the, Section 106 agreement, right? So you can, federal agencies should consider other things related to the federal tribal relationship when they're having conversations about an undertaking. And then, of course, as we've talked about, tribal assumption of HPO functions on tribal land, you'll still see folks saying, yeah, I know this is on trust land, but we're going to invite the SHPO. Well, really, the tribe can invite the SHPO to be a part of that, right? But even if the SHPO is a consulting party, the tribe's historic preservation officer is the lead historic preservation officer on tribal land if they have that agreement with the Park Service in place. Okay, so another important context here, initiate early. I know I've said this over and over again. I often get told that I'm the early and often repeater. I'm like a parrot, but it is just really important, right? Because if someone's already made a decision, then what does really your consultation mean, right? So we really want to make sure that consultation is meaningful, and that this part of the regs, that the Section 106 process should be completed prior to the approval of the expenditure of any federal funds, right? This does not prohibit agency officials from conducting or authorizing non-destructive project planning activities before that, right? There is a bunch of leeway to have these conversations, engage early in the process, have, I know a TIPO that I used to have the pleasure of working with a lot, who would meet very early on with project proponents to say, this entire area, let me circle it for you. Can we just leave that one alone, right? And before the Section 106 process was even fully initiated, just to say, let's not even get down the path, right? So take into consideration tribal review, right? That things take time to work through bureaucracies in all governments, right? And tribes need that kind of same consideration, that those things can take time. planning for for applicants' involvement. If there's any leeway in budget at all to support paying for tribal expertise or helping folks travel or supporting their participation, that's always something that's encouraged. And then, of course, in federal pre-application processes, we have guidance, a handbook out there on how applicants can coordinate with tribes ahead of, excuse me, ahead of the, the formal 106 process in ways that can kind of help folks get their understanding and input in early.
Hey, Jamie, let me break in really quickly and let you know we have a question from, I think, want to go 2 slides back
Oh
from
gosh, I'm
Rebecca
so
Hawkins.
sorry.
No, you're fine. You had started the next one and I just wanted to let you finish. But Rebecca Hawkins asked if you could please clarify what constitutes tribal land for the TIPO program.
Yeah, so in the regs, I like to get it exactly from the regs. Tribal land means all land within the exterior boundaries of any Indian reservation and to all dependent Indian communities. Over time, of course, the entity responsible for interpreting that part of the legislation is Department of the Interior, and they have interpreted that to mean all land within the exterior boundaries of any reservation with a big flag, that any reservation that is currently recognized by the United States as an intact reservation. And for all dependent Indian communities, trust land is considered obviously tribal land. So for situations where you've experienced what has been called quote unquote checkerboarding, so to speak, that is unfortunate legacy of colonialism. In those cases, oftentimes it is just trust parcels that are tribal land, pursuant to the NHPA. But I know that there are some decisions out there that might be impacting how courts over time are going to look at which reservations are viewed as intact by the U.S. government and which ones are not. So like I would say a third of my job when I worked at the TIPO program was liaising with the solicitor about requests about that specific question. So, if there's ever any need for resolution about that, that would definitely be the entity to coordinate with, would be the TIPO program at the Park Service. I'm waiting I'm like, did that do it? I wish I could see you guys. You give like a thumbs up.
Rebecca
Yes.
has another comment back, if you can see it. In the past, tribally owned fee simple land and allotment land were considered outside the purview of the TIPO prior to the McGirt.
Yes. That's correct. Whether, my feelings on it aside, or whether I feel like Oklahoma and Alaska were adequately considered in the development of the 1992, updates aside, yes, that is correct. And, in implementing McGirt, I think the Park Service and Interior have a big job ahead of them in terms of thinking that through for sure. All right. I feel like in Oklahoma, you guys don't even need to hear this from me, right? Like you are very aware of the history of removal and what that has meant to the landscape here. So currently our tribal owned fee simple land and allotment lands under the TIPO's purview. You need to talk to the TIPO program about that. But what I will say is that according to the program's guidance, if a reservation is now considered intact by the U.S. government, for the purposes of, this statute, then that would be the deciding factor. So it's less the deciding factor about tribally owned fee simple or not. And it's more about does that tract meet the statutory requirement of being inside the external boundary of a reservation or not, right? Because for tribes that have reservations with fee simple land and trust land in them that the U.S. recognizes as a reservation, all of that land has always been under the purview of the TIPO. So it's not so much hinging on fee simple or not fee simple. I hope, it's complicated. And, there are days where I'm like, God, I'm glad I don't have to figure that out. But actually, I really wish I did have to help figure that out because it's been a while, right? And you guys definitely deserve an answer about some of that. So in our regs, the requirement for consultation applies regardless of the location of the property in Oklahoma. Again, I don't need to tell y'all that. Y'all know that there are things all over the East Coast that tribes that are currently located in Oklahoma are interested in, east, southeast. You know that very well, but just making sure to help federal agencies understand that, because I know that TIPOs and tribal departments are really underfunded, but so are a lot of federal departments. And they'll say, oh, we'll just make tribal liaison collateral duty. And it's really hard to communicate, especially to offices in the Southeast, that it is a whole job and that it's very complicated. And actually, there are a lot of tribes that the agency should be building relationships with and understanding where exactly they're interested. Another key concept we've already touched on a little bit is sacred sites. So one of the important things to point out about Executive Order 13007 is that the agency does not have anything to say or decide about whether or not a site is a sacred site to a tribe, right? So the language from it says, any specific concrete narrowly delineated location on federal land that is identified by an Indian tribe or individual Indian individual, and excuse me for using the language of these things when they were written, it just feels very dated at this point, but that is what it says, determined to be an appropriately authoritative representative of an Indian religion as sacred by virtue of its established religious significance to or ceremonial use by an Indian religion, provided that the tribe or appropriately authorized representative has informed the agency. So basically, if a tribe or a designated leader, whether that's a spiritual leader, political leader of a tribe, tells an agency that something is a sacred site, it is a sacred site. Right? So that's a little bit different than the NHPA context where you have an agency making a determination of eligibility. And so that's why, we do have a paper about, how do you think through Executive Order 1307 in an NHPA context, because the integration of traditional knowledge or indigenous knowledge into project planning can really help ensure that sacred sites are identified. And it's important to note that while a sacred site may not meet the National Register criteria for historic property, although likely does, and that conversely, a historic property may not meet the criteria for a sacred site, in those instances where an undertaking may affect a property that is also considered to be a sacred site, the federal agency should, in the course of Section 106, consider accommodation of access and ceremonial use of the property and avoidance of adverse physical effects. So in those moments where in the Venn diagram of this universe, something is both a historic property and a sacred site, the Section 106 process should accommodate that. And one of the guidance documents that I've uploaded here and that you'll have access to is about kind of coordinating 13107 and 106. Another key concept, of course, is indigenous knowledge. We already talked about the fact that agencies have been asked to think about and provide information in 180 days about how they're going to implement that new government-wide guidance on incorporating indigenous knowledge. So it's definitely something that agencies have been asked to think about in further detail right now. The Advisory Council has an information paper. The information paper was titled some years ago and called Traditional Knowledge in the 106 Context. But we very much consider it our indigenous knowledge paper for now and intend to kind of extend that and think through a potential further deliverables that include and expound on what we've said there. It is an information paper that does not attempt to define traditional knowledge, but rather to provide tribes and NHOs and other indigenous peoples an opportunity to explain what indigenous knowledge or traditional knowledge means to them. It was developed in collaboration with tribes, Native Hawaiian organizations, and really lays out that indigenous knowledge can provide information that greatly enhances a federal agency's ability to make historic preservation decisions that respect, value, and take into account historic properties of religious and cultural importance to tribes and NHOs. So this fun, first of its kind guidance, and this is a quote from it that's really help, kind of an overarching quote, is in addition to regular, meaningful, and robust nation-to-nation consultation, the U.S. government can fulfill its trust responsibilities to tribal nations, recognize sovereignty and self-governance, and honor its commitment to strengthening relations with indigenous peoples by including indigenous knowledge in federal decision-making. So all agencies have been asked to submit a progress report in 180 days on what they've done to implement this guidance. So something that, again, if you work a lot with a certain agency, you might want to ask, hey, what is your plan for this look like? Got a little shout out here, the National Historic Preservation Act. What was said about the NHPA in Section 106 in here specifically is that Section 106 of the NHPA establishes a process to ensure that agencies take into account the effects of projects they carry out, license, or assist, and requires agencies to consult with any tribal nation or NHO that may attach religious or cultural significance, and directs agencies to recognize the special expertise of tribal nations and NHOs, including indigenous knowledge in the Section 106 process. So there's a specific 106 call out here. So some key messages from our IK paper is that this knowledge is defined by tribes and indigenous peoples, Native Hawaiian organizations. It is the responsibility of the federal agency to acknowledge this special expertise, and that it is frequently expressed through traditional knowledge or indigenous knowledge. Federal agency is required to consult with tribes and NHOs and integrate any shared indigenous knowledge, traditional knowledge in the identification and evaluation of historic properties, assessment of effects, and resolution of adverse effects. One of the things prioritized in that paper is that information shared might be confidential and should be respectfully and appropriately protected by federal agencies in the 106 process. So, you know, there's not currently an overarching FOIA exemption for indigenous knowledge, right? So we need to be careful about administrative record and communicating openly all along about how expertise and knowledge can be protected. Early coordination and long-term positive relationships can facilitate the timely integration of indigenous knowledge, because it does take a lot of trust to share information that is, you know, crucially important to the perseverance and relationships of a community and nation. So identification is a big part of this picture too. I think many assume that agency or contract archaeologists can appropriately identify historic properties of significance to tribes and NHOs, but it should not be assumed that an archaeologist or any federal personnel possess the appropriate expertise to determine what properties are or are not of significance to a tribe or NHO. The appropriate individual to carry out that determination, of course, is a representative designated by a tribe or NHO, so that acknowledging that special expertise and you know, elevating the importance of oral history, ethnobotany, place names, traditional use, traditional knowledge in that picture, really important. Wow, there's a lot of slides. Maybe I just wanted to show you this beautiful picture. But a lot of slides on IK. Again, just to reiterate, it's important to all four steps of the process. It is information and expertise. It should not be referred to by, you know, other words like legend, storytelling. We often see some people say science and anecdote. It's like, no, this is all evidence, right? And the guidance really lays that out as it's expertise. That tribes and NHOs are the experts about their histories. Special expertise includes indigenous knowledge and has a special place in the legislation is important. And our kind of information paper affirms that traditional knowledge / indigenous knowledge is special expertise for the 106 process. So it's been our information paper seeks to raise awareness. It's a first step that we'll definitely be following up on. I'm going to see questions, chat. I know if I'm getting tired of my voice, y'all must be too. All right, opportunities and challenges. You know, cultural and legal processes and protocols may exist that govern access to, sharing of, and the use of indigenous knowledge. When the U.S. government is seeking information about potential impacts of federal undertakings on historic sites from federally recognized tribes, there are nation-to-nation protocols and legal frameworks that also need to be considered, but also internal processes that tribes have from a governance and cultural perspective. These complexities, of course, are no surprise to those of us on this call who have worked over time very closely with tribal nations and communities, but adjusting the federal bureaucratic mindset to understand them and how they can affect timeline can be challenging. Internally, communities may be concerned about harm that may be done by sharing information, and sometimes this puts them in a difficult situation because, especially if an undertaking might harm a property of significance, to say a religious practice, right? But what if sharing the information also does harm, right? So really kind of recognizing the complexities of this from the other side of things can do a lot for relationship building. Just recording certain types of knowledge and expertise may actually threaten them or their survival and their survival of crucial parts of practicing religion and culture and heritage. So knowing that and being creative about protocols and talking openly about protocols is very important. It can be difficult, on the tribal side, working with laws that were most created by non-Indigenous people, right? And to think through how much information to give and in what context. Indigenous knowledge is essential to identify and evaluate properties of religious and cultural significance, and yet these complexities around sharing Indigenous knowledge require trust and may take time. Permission might be needed, right? So protocols, again, very important to this process, and really just emphasizing that Indigenous knowledge is a valid, sufficient form of information. So another breakdown in communication I've seen over the course of my career will be when a tribal nation will state, this is an area that is important for this reason, and it's crucial to our history in this way, and it's crucial to the perpetuation of our living culture in this way. And a federal agency will say, well, the archaeology doesn't back that up. It's like, what? Like, and again, not trying to pick on archaeologists. There, are a bunch of lovely archaeologists out there, but I have seen, right, that if something shared through an oral historical fashion or through ethnographic research with a federal agency, it doesn't need to be backed up by another source. It's not a weaker source of information, right? There's not support in the regulations for a statement like that, right? So just kind of sharing that. There might be different views on a property, right? And each is valid. So we're not going to invalidate knowledge shared about a property, and we're not going to call one person's knowledge a belief in the other person's expertise, right? We're going to be really careful about respecting knowledge as expertise. All right, so the world we're all in, right? Challenges in consultation. So context change. This is true not only on the tribal side, but also on the federal side. Keeping up to date with contacts and making that a priority, I think, is actually like a really important part of meeting our responsibility to relationships, right? So, I've gotten flack over my career for spending too much time chasing down a phone number or an email, and I see people say, well, it's only our responsibility to use the email listed on the website or whatever. And it's like, no, I actually think it's pretty important to make sure that we're keeping up to date. And if we can't get a hold of somebody who might be really interested in an undertaking, to really try to call them, call the tribal offices, have conversations with people, right? There's people on both sides of the phone line, and it's easier than I think people think to make those calls. Volume, right? So volume of projects on both the tribal side and federal side can be a challenge. Staffing on the federal and tribal side, right? I think sometimes people like to talk about how understaffing is a huge issue for the thousands of requests tribes get for consultation, but let's be real, it also is on the federal side, right? You'll have an entire region of a federal agency with one tribal liaison with additional duties as assigned, right? Just doesn't cut it for the importance of the responsibility. My personal opinion, right? Not the ACHP's, is Jamie Lee talking right now. But staffing can be a huge challenge. Transparency about confidentiality, right? So, just making sure that people understand the limits of what can be kept confidential once it makes the administrative record. Really important, and trying to work creatively around that. And then the delegation of 106 authority by federal agencies is an important part of this picture, I think, for all of us here today. So, again, checking the chat and Q&A. Okay, good. Now I'm worried about missing something important. Federal agency is allowed in some circumstances to delegate to its applicants the responsibility to initiate consultation in the 106 context, but that does not apply to the initiation of consultation with tribes unless expressly authorized or agreed to by the tribe. And I think this, unless agreed to by the tribe, is something that, can get glossed over. So I've included our guidance on limitations of delegation of authority by federal agencies there. And also just to say that tribes are not obligated by statute or regulations implementing 106 to consult with applicants. Nothing in the 106 regulation is intended to, or even legally could, waive tribal rights to the government relationship and consultation. Helpful practices. I see folks, working with tribes and with TIPOs here. So just to say, I think entering into agreements with agencies and applicants about what constitutes consultation, what that needs to look like, developing protocols for early coordination, maybe even pre-consultation coordination, creating the administrative record And, if someone says something on the phone to you, following up, put it in writing, make sure to track that as much as you can. Same thing that we would say, of course, to federal agencies is cultivate and maintain relationships. It's a lot easier, to care to care about people when you care about them. I don't know, that's like a Southernism that I say, but when you care about someone, you care about them. So building that relationship, like we all have something in common, and it can be a really helpful way to kind of build that trust, and especially when things don't go how everyone wants to, like make it through those tough times to the next project. Um, and just share, right? Share hurdles, data gaps, staffing shortage, workload. I've seen instances where a federal agency will say, oh, we need a response by this date. And sometimes that's really true for the project. But sometimes, hey, this is what's happening here. Hey, this is a really important week for this reason. Can we get 7 extra days getting that in writing, instead of letting it come and go? I've seen that be a successful approach. Protocols, of course, about who can facilitate interaction, when and how, and define your expectations of the applicant or agency can be extremely important. And then getting creative again about like talking about confidentiality, having those kind of quick conversations about, hey, this is actually some pretty sensitive information. Like, what do we need to do to comment effectively here? And then helpful practices. On the federal side, the delegate side, build relationships, meet on a regular basis. I know, as much as is feasible, you learn a lot, like reading annual newsletters or going to, events or consultations, or just generally meeting. I know when I worked at the Park Service, regions tended to have like a once a year meeting just to hear what's going on in the community, right? That how do you know what's going to have tribal implications if you're not even aware of day-to-day life and the concerns and what's going on there? Consult early and often. Again, I'm the early and often parrot, so I'm going to say early and often. Consultation agreements, very helpful to have in paper. Who can initiate consultation on behalf of the tribe and who is going to be there on the agency side. Document the process, but keep in mind documentation is not the goal of the process. It's really important. And developing mutually acceptable standards or protocols for identification and evaluation, right? So that conversation about like what would it look like to really evaluate the significance of a site, and have like, is it appropriate for that to just be an archaeological study, or would it need to be something else, right? So engage in those conversations and consultation. Treat tribal representative as the experts they are, right? So we see that being an overarching thing that is helpful. You're already doing this, so you pat yourself on the back and, I don't know, have an extra treat today, but work towards, really engaging with the broader world of historic preservation and federal Indian law in the U.S. context, right? Because it is a bigger picture. I think sometimes 106 can seem like, a really narrow lane. And I do work in a narrow lane here at the ACHP, but folks engaging in government to government consultation, 106 is just a part of that world, right? And that's true on the tribal side, it's true on the federal side, and understanding how the pieces put together will make you a better, colleague slash partner slash person to work with for tribes, because certainly they're thinking about these things together, right? So just because we chop up work on our side a certain way doesn't necessarily mean that's true for other governments. Stay informed, visit tribal websites, read newsletters. For those of you who are interested in the Supreme Court cases, read Turtle Talk, get in there. There's lots of resources on there to keep up to date. I know we all have a million hours in a day and it's all really easy, but these are just some tips, right? For if you ever do get downtime. Update your contact list. I'm just going to say, I don't put this on a slide because I don't know how it comes off, but I like to take notes about people. So like when I meet people, especially if like I meet their family or their kids, like I'll know the name, right, for a week, but maybe I don't see them till the same conference a year later. It's like nice to remember like what people's kids' names are. So I'll have my own, not on my government computer, little Jamie Lee, like database of like, okay, people's kids are growing up. I care about and I like people, and I think that goes a long way. If you care about and like people, making the extra effort to understand that they're human beings with lives can go a long way. And then the United Nations Declaration on the Rights of Indigenous People, right? People are increasingly thinking through the importance of this document. The ACHP is thinking through ways to incorporate it into what we do. And there are several tribes that have formally adopted the declaration too. So, I mean, that could be a whole other presentation. So I will just leave it at that, but it's an important document that your tribal partners are thinking about. Don't dismiss concerns because you view them as outside of the scope of 106. Like, I mean, just to be very blunt and Southern, like, how could you know that they're outside of the scope of 106, right? Like, how could you know that they don't negatively impact the integrity of a historic site or property, right? So don't be open-minded about that, especially because you can coordinate 106 with protection of sacred sites and other things like that. You know, we've I've seen in my career folks say, oh, well, this is about, you know, whether or not a certain species of animal can access this, not realizing, okay, that species of animal is actually really important to the historical and current perpetuation of a practice that is essential to life for that tribe, right? So just being open-minded, and wherever feasible, accommodating those concerns within the scope of your agreement or your project. Whew. ACHP, like I said, we're up in our own business. We're up in everybody else's business. We've got some guidance out there on consultation with tribes and Native Hawaiian organizations and a bunch of other things. Some of the main ones that I'd like to draw attention to is this handbook, Consultation with Indian Tribes in the Section 106 process. There's also early coordination with tribes during pre-application process as a handbook. And then specifically discussion about relationship between executive order on sacred sites and 106, indigenous knowledge, recommendations for improving federal tribal consultation. Oh, I listed executive order 13007 twice. That must be like the biggest piece of evidence that I'm thinking about it a lot these days. Guidance on the removal era in section 106 consultation and treaty rights in section 106. That's all out there. We've, of course, got some e-learning, early coordination with tribes for infrastructure projects. We have Section 106 training for tribes. That's on-demand e-learning whenever. And working effectively with American Indian, Alaska Native tribal governments was a training that Bill Dancing Feather in our office worked with DOJ, Department of Justice, and Bureau of Indian Affairs on. So it's the broader, again, on that broader picture. I do want to, oh gosh, Christina, we'll see if I can figure this out. I do want to share briefly one of the files I uploaded. Is that a thing? Maybe it's a thing. We'll see.
I think we can make that happen.
Okay.
Can you tell me which of the files?
Yes, like the one pager.
Yes, absolutely. Just 1 second,
Oh
and
my
I'll
gosh, you are
drop
a
it in.
wizard. Do I got to remove this one?
No, I think I got it. Are we there?
Yay! Awesome. Thank you so much.
Sure.
Yeah, so I uploaded a whole mess of documents for y'all on this on this portal, but I also made a one pager that links them all, right? So if you're like, wow, I really don't want to download 100 things from Jamie Lee, here's a one pager that links them for you so that you can just have that kind of one document to use to go to. So that's the one I would definitely download if you aren't in the mood to download 15 things, and that kind of lists for you general tribal consultation executive orders and memos, the ACHP's handbooks and information papers, our policy statements on our own trust responsibility here at the agency, and then, of course, our e-learning materials. Oh gosh, now I got to drive again. Let's see. All right. That was, I'm impressed that it's that I've made it through that, but that was what I had prepared today, and I'd love to hang out and we can do some Q&A and discussions. I mean, those of you that work in this every day, I'm sure have a lot to contribute about these themes. So just thanks for the opportunity to be here and to connect with y'all.
Well, I really appreciate your presentation, Jamie Lee. Thank you so much. I hope we'll have some folks that will enter questions or thoughts in the chat or in the Q&A here. But while we wait for that, I will remind everyone that we have some additional presentations coming up next week, beginning Monday with Matthew Pierce. He will be presenting on working with the National Register of Historic Places. And you guys can register for his workshop or any others in our series on our website at okhistory.org/shippo/workshops. And we really appreciate you being willing and able to come give this presentation. Thank you so much, Jamie Lee, sorry.
I mean, thank y'all for being here and for putting on this amazing training series. Do you do it every year?
We do. We do these trainings twice annually. We do them in December and May usually, but a winter and a spring presentation.
I got to register. I want to hear what the National Register folks are going to say, especially.
Well, we'd love to have you. We'd love to have you attend. You're always welcome. Thank you so much. I will end the recording here and thank you.